My name is Timothy Brown. I am the owner of Timothy E. Brown, CPA, LLC. Thank you for joining us this evening on this broadcast about wills and trusts. What we would like to do is bring you informative information for you, the client. My guest today is attorney Nicole Massiah. Nicole, thank you for joining us today. Introduce yourself. Tell the audience something about yourself.
Well, first, I want to thank you for having me here, Timothy, but also thank your audience for participating. Again, my name is Nicole Massiah. I am an attorney here in Atlanta, and I am the principal attorney at Massiah Law and Associates. And at Massiah Law and Associates, we serve our clients. We make sure that we fight hard and we are passionate for our clients. With that being said, our practice area is civil law, specifically wills, states, and a trust, but also family law. Again, we serve our clients at Massiah Law and Associates.
Thank you, Nicole. Thank you for that information. It sounds like you do a great job. So that's why we have you on today. I like to bring experts to my clients so they can get some information. I get those questions all the time about wills and trusts.
Yeah.
So I thought, how can I bring this information to my clients? And then I thought about you and your expertise in that area. So that's why we have this video today. So what we'll do is jump right in with some of the questions that some of my clients have provided. So the first thing we'll do is just start with the basic question.
Okay.
Is what is a will and what is a trust?
Well, in summation, to make it as simple as possible, they are instruments in which they allow an individual to dispose of their assets. And what I mean by dispose of is distribute it, determine where it's going to go. People work hard for their belongings, whether it's their home, whether it's other tangible items such as maybe it's a fur, maybe it's a car. Or maybe it's invaluable things that they've ascertained that they just want to leave to their loved ones that may not have actual monetary value, but have sentimental value. And you want to make sure it gets to the person that you want to have it at your death. So a will and a trust, again, to some eyes, are instruments so that you'll know and you can decide what you want to go to your loved ones and where.
Okay. All right, great. So the next question is, when should someone start considering a will or a trust?
Well, I believe that a person should start considering a will or a trust as soon as they realize that they have belongings, assets that they want to leave another individual. Specifically, it typically happens when someone starts a family, for instance, or when they get married. At that point, the spouse, if there is not a will, that person passes, then they will die intestate. And then the particular county, it will be probated, and the particular county will determine where those belongings will go. So a lot of times a person will, start their will and or their trust once they marry or they have a child and they decipher that they only want a part of their funds or part of the belongings to be distributed to the child at different times, right? At that point, they'll, go ahead and get a will or a trust. So it's usually a big change or event, in summation, a big change or event in someone's life when they realize that they need to decide legally where those items, where their belongings, what they've worked hard for, it needs to go.
Okay, great. Question, follow-up question on that. So does that mean, is that based on age or any other factor other than a life-changing event?
So typically people start having children and getting married in their mid-20s to their lower 30s. So that's typically the time frame where you start seeing people that are actually shopping for a will or trust. As long as you are an adult, you can actually execute an instrument such as a trust or a will. So there's not a time limit from that perspective. And on the converse, you can be 80 years old and decide that you need to make sure that you know where those belongings, where your belongings are going, and decide then that you want a will. There's no specific time, limitation or age limitation. However, it generally starts in about 20s to 30s when people start amassing things such as property or cars or things of value.
Great information, because a lot of times people think, oh, I'll do that when I get 50, 60, etc. But basically what you're saying, even in your 20s and 30s, if you have assets or you have a spouse or anything like that, children, you need to be advantageous to get a will or a trust to make sure that those assets are left the way that you desire legally to those individuals.
Absolutely. I mean, we're living in an age where you just never know, especially dealing with, some of the pandemic. Unforeseen circumstances come in different ways, and it happens all the time. So it's never too early to prepare where you want your assets, your estate essentially, to go.
What are the differences between a will and a trust?
Well, the general difference is that a will takes place and comes into effect when someone dies, whereas a trust, that can take effect while they're living.
Okay, great information. Okay, now just to piggyback on that, what are the advantages and disadvantages of each?
Okay. There's several. Just in general, a will tends to be more public opposed to a private. So if a person has an interest in keeping how he's going to dispose of his assets sort of more under wraps and secretive, then they might want to put it in a trust opposed to a will. The other thing is that wills are probated, whereas trusts are not. And so that sort of goes to the idea of the private versus public, because your will can become public record, whereas your trust typically does not.
Okay. Why should you hire a professional and not do these online?
One of the reasons why I suggest a person not do a will or especially not a trust utilizing an online downloadable form is that you don't know whether or not that's going to be valid. And to the extent your will, for instance, is challenged, then you might run into a problem. You might run into a foul where what you had determined you want to happen doesn't, because you have a judge that then scrutinizes and can make a different determination to the extent that it's not legally valid. So you don't want to do it online unless you're an attorney. You don't want to draft it yourself, because you need to have that intimate legal knowledge to make sure that it will hold up.
Yeah, great information. The next question we have is, how often do wills need to be updated?
Going back to one of the time frames that most people tend to actually get a will in the first place, typically when someone gets married, right? Or someone has a child, when the big circumstances of your life change. You want to make adjustments for that. Other times are let's say for instance, someone dies that's named in your will, right? Or you adopt someone, you adopt a child. Another time would be if you decide that you want to change your executor, i.e. the person that you want to be charged and administrate your will. And so you want to change it when you've made a determination you want somebody different.
When updating wills, do you have to redo the entire will, or can you do an addendum to the current will?
And so what you refer to as an addendum, we refer to as a codicil. Okay. And essentially it's making an adjustment to the will without having to change the will in its entirety. Okay. So it's common to make a codicil in a will and account for some of the changes that we just talked about, we just discussed, opposed to drafting a whole nother will, which could be in some cases expensive. The
trust, the mechanism used to leave an inheritance to your grandchildren.
It can be. You can leave an inheritance to your grandchildren. You can leave monies to your children. You can utilize it to leave monies to a charity. You can utilize a trust as an instrument to leave money for any of those individuals or entities. So absolutely you can use it to leave money to your grandchildren, But consider, if you do that, consider who the trustee will be. As I mentioned, as it relates to a will, being mindful as to who the executor is, you definitely want to make sure that you're mindful as to who your trustee is. And so if you're going to leave it to grandchildren, consider whether or not you want their parents to be the trustee, or if you want to designate some other individual to be the trustee over that particular estate.
Okay. And just to comment that because we live in the real world,
Yes.
and I'm quite sure you've seen this, in some cases, you bypass the parent for whatever reason, and thus you don't want maybe that parent to be the executor or the estate or the trustee. So, okay. And it goes back to your comment. That's why you have a will of trust, to be within your will.
Absolutely. And it piggybacks on the question as it relates to doing it yourself via online. That's why you want it done right, to make sure what you want to happen, when and how, is what happens.
Okay. Can you have both a will and trust at the same time?
You can, absolutely. And so you can have a will and a trust. And typically, someone that has larger assets will have both. So you definitely can. When it comes to a will, I suggest a will if you don't have a lot of assets, if you don't anticipate a lot of fighting or issues going on as a result of what's in your will. As it relates to a trust, when you have larger assets, and let's say you have entities like businesses, and then you need to be very specific, or you want, instead of things being distributed in one lump sum, which would happen in a will, or at one time in space with a will, with a trust you could actually specify when and how, during what period you want what to take place, right?
Yes.
On conditions. And so you definitely can have both. They serve different functions, but collectively, especially when you have a lot of assets and a lot of complexities, can work in conjunction really well.
Okay. Follow-up question to that.
Yeah.
So could a will, especially if you got a lot of moving parts with your with the assets that you have, could the will be something, for lack of a better term, simple, just to get you through the funeral, so to speak? Hey, you need X amount of funds, or do this, or this, just to see the family through the first week or two, and then after that, maybe everything goes to the trust because it's more involved.
And so I wouldn't limit it to a short time frame, like a week or two. But to your question, it goes to an immediate distribution, if you will.
Okay.
Sometimes in order to execute the will, it does take longer, right, to satisfy the terms of the will. But in general, it's more finite in that as long as there aren't any hiccups and aren't issues and people are actually following the terms of the will, then it can be something more immediate, opposed to a trust, which is going to be, arguably ongoing.
Yes. Okay. All right, great.
And that's another way they work together, and why you can have both.
Okay. All right, great. So what are the costs for a will or trust?
So how much a will or a trust or a trust actually costs really varies depending on the complexity of both. It usually has to deal with the number of the assets, the value of assets, how they're actually being held. I would say, just to start, there have been some wills I've drafted that started at roughly about $1,500, where that's very simple, where a person really hasn't amassed anything. There aren't a lot of complexities in it, whereas there have been $10,000 and $15,000 wills. And in those particular instances, there were businesses involved. There was just more complexities. Similarly, with a trust, same idea. Trusts tend to start higher in terms of cost because they're more ongoing, opposed to a will. So trusts usually around $7,500, but they can go up to the tens of thousands depending on the complexities and the number of heirs and just all the nuances. It's really difficult to sort of pinpoint, but generally $1,500 for wills. You can get someone to draft one for $7,500 for a trust.
Okay. Would an insurance policy be impacted by the will?
So if someone is named as a beneficiary in insurance policy, then they wouldn't be impacted by the will because insurance policies aren't probated. If it's not a part of the will, and insurance policies are not a part of the will, then it shouldn't have any impact at all. As it relates to an insurance policy, the named beneficiary is the person that would get the insurance proceeds. That's separate and apart from a will.
Next question. What happens if someone passes without a will or trust?
Then the court has to get involved, and at that point, the person is considered dying intestate. That means they're dying, or have died without a will. The court gets involved and determines where the assets, if any, goes and settles the estate. The court gets involved. There's also an administrator opposed to an executor that would be named in the will. So whereas if you have a will drafted, then you can name your executor or the person that can administer your estate. Whereas if you die without a will and you die intestate, then the court will appoint an administrator. And so it could be, and sometimes it is, a family member or someone that's close, but in some instances, it's a county administrator, someone that didn't know you, for instance, especially where there's a conflict between the families. Someone that didn't know you has no real idea as to what your thought process may have been as it relates to your assets or where you would have wanted things to go, or whether or not you would have wanted your brother to inherit the farm, or if you would have preferred for it to go to your sister. That's one of the things that a judge will determine as it relates to your estate, opposed to you making that determination.
Okay. Question. What are some of the common mistakes you see when people get a will?
Besides them trying to do it themselves, I would say not paying as much attention as they should as it relates to who they name as their executor. And usually when it comes to a trust, people are a little bit more mindful as to who they name as a trustee. But determining who is going to administer your wishes. Sometimes people will follow your wishes, other times they don't. But also they need to be educated as to what their role really has to be. And I say has to because they have a duty. They have a fiduciary duty at that point to execute in accordance to what is on that document, whether they like it or they don't. So I think a lot of times people make a error in who they've actually appointed and determined who would be their executor. But also another issue is that when a person decides, yes, and they, I'll be your executor. I think there's a huge error as it relates to people agreeing, because they have to agree to actually be your executor. I think a lot of times when a person agrees to be an executor, they don't realize the responsibility and the obligations that come with that. Mm-hmm. And again, I know that they like to a lot of times make their loved one feel better in terms of, when that loved one passes, that they'll be there and they'll stand and do what's right. But there's a lot of responsibility and obligation that comes with that. Yes. And I think a lot of times people just don't realize that, and it gets them in trouble.
Okay. All right, great. All right. So next question. Heir property. I've seen a lot of stories in regards to people losing the family farm, right. So from relatives who live in far away and most cases, in some cases, haven't even been to the family farm or local family property. Can give us some information on heir properties?
So I understand, that concern in that there's been a lot of individuals that tend to lose the family farm, if you will, or family home in rural areas, specifically because a lot of those folks may not have been as sophisticated, and in some instances, it just passed down generation to generation. And then you also have predators that specifically target, individuals that may have had property in a rural area, and they have a family member that lives in another state, and that family member may not have been as concerned. But there's just so many different nuances and a lot of things to sort of, pinpoint, and it's just a bigger issue that we have the opportunity to really share with your viewers today. If they'd like more information, though, I am happy to sit down with any of them. We're also on the web, of course, Massiah Law and Associates, or any of the social media handles at, again, Massiah Law and Associates. MASSIAH Law and Associates. Mm-hmm.
If I own real estate, should I put it in a will or a trust?
It depends. Is it just a family home that you lived in, or if it's an investment property? It really depends. You might want to put your home, your residence, in a will, but if you have an investment property or a commercial property, you want to set up a trust and put that in a trust.
Okay. Next question, are funds that are in trust easily accessible?
That depends on the trustee. It depends on how responsive the trustee is and whether or not what the mechanics are for them to actually access the trust and to be able to ascertain those funds to be able to provide to the individual that are requesting it.
Okay. All right. The next question is, so when an individual is setting up these trusts, do all of the professionals work together? For example, the CPA, the attorney, and the financial planner, do they work together, or how does that work?
So a lot of times as attorneys we'll work, by ourselves, but it's advisable. And I would suggest that they work closely with their CPA, that they give us an opportunity to work closely with their CPA. Absolutely. So as it relates to an estate, postmortem, premortem, there are things that you can definitely do to maximize the estate where a CPA very much should get involved as it relates to transferring, for instance. And, in the planning of it, they could avoid certain estate taxes as it relates to pensions. I mean, there are just different mechanics that are involved where it's important to be able to structure and put those things in place the right way to be able to transfer them when necessary at the right time so that you can maximize the value of the estate. And with a CPA, as an attorney, we can do that collectively best versus doing it separate.
Okay, great. Well, those are all the questions that we have today. Do you have any additional information you would like to share with the audience?
If you want additional information, feel free to reach out to me, Nicole Massiah at Massiah Law and Associates. I'm happy to help.
All right, thank you. So I want to thank everyone for joining us today. Again, I want to thank my guest, Nicole Massiah, attorney Nicole Massiah. And again, my name is Timothy E. Brown, the owner of Timothy Brown CPA LLC. I can be reached at my website, tebcpa.com. You can schedule a consultation right through the web page. Okay, again, thank you for giving us your time today. Until the next time, have a great day.